Hi students, I am going to take up for discussion today lesson number 18 of the SBEC module, which is compliances relating to environmental laws, provisions applicable for setting up of business. So basically this chapter is a very easy chapter. It speaks about some 5 or 6 environmental laws and what are the compliances under these laws which are to be undertaken by the firms or by the companies when they start a new business. Okay, so I have made very simplified version of pointers under for each of these environmental law. So let's discuss them. So the first act, environmental act that we will cover is the Water Prevention and Control of Pollution Act 1974. So first, in any act, what is the first thing that you should remember? What is the purpose of the act? And usually the purpose is explanatory from the name of the act itself. So it is, the purpose of this act is to provide for prevention and control of water pollutions and to maintain or restore wholesomeness of water in the country. So prevention and control of water pollution, you can just make out from the heading itself. Okay. And second, it prohibits the discharge of pollutants into the water body. So if you want to prevent water pollution, so you will prohibit the discharge of pollutants in the water bodies beyond a given standard. And also this act lays down penalties for non-compliance. So it is very easy to remember. And this act has provision for 2 kinds of boards: Central Pollution Control Board at the central level, and at the state level there is State Pollution Control Board. The next act, which is relating to water pollution, is the Water Prevention and Control of Pollution Cess Act 1977. So basically this act is related to the first act, Water Act. How? Let's study about it. What is the purpose of this Water Cess Act? It provides for the levy and collection of a cess on water consumed by persons operating and carrying out certain types of industrial activities. So what does it say? That there are certain kinds of entities which carry out their business and activities in such a way that they will be causing water pollution, okay, up to certain limit. So they have to pay a certain cess. It's kind of a tax, you can say. They have to pay certain money. Okay, so that is covered by this act. Cess is collected with a view to augment the resources of the central board and state board for prevention and control of water pollution. So whatever cess amount is collected from these entities is used to finance the central and the state pollution control board under the Water Act. Also, it provides information to the State Pollution Control Board to provide access to the State Pollution Control Board for taking samples and allowing entry to the State Pollution Control Board to ascertain that the provisions of the Act are being complied with. So this is the main purpose of the Water Prevention and Control of Pollution Cess Act 1977. So under each of these acts, we are going to study what are the responsibility of the company. So responsibility of company under the Water Cess Act is to obtain, it has to obtain a consent to establish its in the setup. Then it has to obtain a consent to operate. Then it has, suppose the consent to operate has got expired, then it will apply for renewal. Okay, in case the consent is refused, then it has to be recorded in writing. Then those entities, they have to pay water cess. Then they have to also affix water meters in their industrial establishment. Then they have to provide access to the State Pollution Control Board. In case there is a delay in paying water cess, then they have to pay interest. And if they do not pay, then they have to water cess, then they have to be paying penalty. And industry is entitled to 25% rebate. Rebate means discount if meeting certain conditions. The next act is the Air Prevention and Control of Pollution Act. This act is also similar to Water Act, just the word water will be replaced by air. So what is the purpose of Air Prevention and Control of Pollution Act? To prevent, control and abate air pollution. Prevent, control, pollution, all these words are coming from the heading itself, so it is easy to remember. Again, under the Air Act, there are bodies at the state level and central level. And this act empowers the state government after consultation with the State Pollution Control Board to declare any area within the state as air pollution control area. Okay, so the central government together with the State Pollution Control Board, state government together with the State Pollution Control Board can declare certain areas as air pollution control areas. Under this act, establishing or operating any industrial plant in Pollution Control Board requires consent from SPCB. So these areas which are declared as air pollution control area, there if you want to establish any industrial plant, then that person will require consent from the Pollution Control Board. And the Pollution Control Board are also expected to test the air in the air pollution control areas, inspect the pollution control equipment and manufacturing process. Again, under the Air Act, the responsibility of the companies are similar. Again, consent to establish will be required. They have to provide information to the State Pollution Control Board. They have to provide access to them. They have to allow the State Pollution Control Board to implement the act, to take samples. Then the entities have to obtain consent to establish, consent to operate, and renew the consent letters. These points are very similar to the Water Pollution Control Act, whatever are the responsibilities of the company. So you can just read through. The next act is Environmental Protection Act. So this is an umbrella registration, means it covers all kind of all items like water, air, land, everything, all the components of the environment. Okay. So what is the purpose of Environment Protection Act 1986? Protection and improvement of the environment. Protection comes from here only, environment also comes from here. So protection and improvement of the environment. And as I mentioned earlier, it's an umbrella legislation designed to provide a framework for coordination of the central and state authorities established under the Water Act and the Air Act. The definition of environment is mentioned under the Environment Protection Act. It says environment includes water, air and land, as well as the interrelationship which exists between water, air and land and human beings and other living creatures, plants, microorganisms and properties. So it is a definition which includes all the aspects of the environment. You can just remember the definition now. Now under this act, certain powers are provided to the central government. What are these? Let's study. To take necessary measures to protect and improve the quality of environment. How? By setting up standards for emissions and discharge, regulating the location of the industry, management of hazardous waste, protection of public health and welfare. Also, from time to time, the central government issues notifications under the Environment Protection Act for protection of ecologically sensitive areas, or it issues guidelines for the matters under the Environment Act. What are the penal provisions under the Environment Protection Act? In case of any non-compliance or contravention, the violator will be punishable up to imprisonment of 5 years or fine up to ₹1 lakh or both. And in case of continuous violation, this is one-time violation. Continuous violation, additional fine of up to 5,000 each day of failure. And still, if the violation continues beyond 1 year, then the offender will be punishable with imprisonment up to 7 years. What are the responsibilities under the Environmental Protection Act of the companies? Firstly, it has to comply with all the directions issued by the central government. It has to prevent discharges or emissions exceeding the limits. It has to furnish information of any accidental or unforeseen event. It has to allow entry and inspection to a certain compliance. Allow, again, common point, allow samples to be taken. Then it has to submit environmental statement every year to the State Pollution Control Board. And it has to obtain environmental clearances from the Ministry of Environment and Forest in case any new project is there or for expansion or modification of any existing project. The next act is the Public Liability Insurance Act 1991. What is the purpose of this act? It is to provide compensation for the damages to the victims of an accident of handling any hazardous substance. If you are working in such an industry where hazardous substances are being handled, and if you happen to meet an accident, then what would be the compensation, damages payable to the victims, that is covered under this act. And also this act saves the owner of production or storage of hazardous substance from hefty penalties. The person to whom that particular hazardous industry belongs, उनके लिए भी liability कम करने के लिए provisions है in this particular act. And how that is done, it makes provisions for compulsory insurance to be obtained by the owner of these kind of entities which handles hazardous substances. So what are the responsibility of the company under this act? Owner to provide relief or in case of death or injury or damage to the property from an accident on principle of no fault. Then owner has to draw insurance policy more than its paid up capital, but less than rupees 50 crores. Then this is just the definition, that the owner has to pay additional amount as contribution to environmental relief fund. Owner has to provide the necessary information. Owner should allow entry and inspection. Owner to pay amount of an award as specified by the collector. Whatever the collector will say कि आपको इतना pay करना है तो वो pay करना पड़ेगा, and it has to comply with the directions issued by the central government. Next act is the National Green Tribunal Act 2010. What is the purpose of this act? So from the name, what it suggests, that one National Green Tribunal, okay, is set up. Why it is set up? To deal with environmental related disputes. It's just like a court, you can say. Just we say civil court, high court, criminal court. वैसे National Green Tribunal is a tribunal which is set up to deal with environmental related dispute, and for the easy disposal of these cases and giving relief and compensation for damages to persons and properties and for matters connected thereto. Now, what will be the composition of this National Green Tribunal? It consists of a chairman, which will either be a present or a retired judge of the Supreme Court, and there are various other members and experts. What is the nature of the case which is handled by National Green Tribunal? It would mostly be civil cases. However, it is not bound to follow the civil procedure code. It has to be guided with the principle of natural justice. And at the time of giving orders, they have to apply the principle of sustainable development and also the principle that one who pollutes has to pay. The National Green Tribunal has the same power as a civil court when they are deciding the matters, and they are not bound also by the rule of evidence under the Evidence Act. The National Green Tribunal has 5 places of sitting, and Delhi is its headquarters, and these are the other places. And the National Green Tribunal can only deal with the following environmental laws. Only the cases under these laws can be dealt with by the National Green Tribunal. Some of them we have already studied about. In fact, most of them we have studied about. And this is one point to remember, that anything which is not covered under the 7 Act, the National Green Tribunal is not competent to admit the suit for that matter. Now, you can file a suit with the National Green Tribunal up to 5 years from the date on which the cause for compensation has arose. However, after beyond 5 years, if the tribunal finds sufficient grounds, then it will allow you additional maximum 60 days for applying. Now, who can file a suit with National Green Tribunal? Either the person who has sustained the injury, in case the person has got injury, but उनका property damage हुआ है, तो फिर owner of the property to which the loss is caused. अगर वो person of expire हो गए हैं, then the legal representative of such a person can file a case. And also this government, central or state government, or the government agencies relating to environment, मतलब Central Pollution Control Board or State Pollution Control Board can also file suit. Also, the person can argue their own matter. They do not have to be an advocate for that particular purpose. And only the thing is that they have to be dressed formally and they have to communicate in English. Now, what is the relief that the National Green Tribunal can provide? It provides compensation to the victims for any loss which is caused. Also, the Act provides for fast delivery of justice, and they are going to make all efforts to resolve the issue within 6 months of filing the suit. However, if the person is not satisfied, it can apply for review of decision of the National Green Tribunal. Even if still they are not satisfied, then they can file an appeal with the Supreme Court of India within 90 days of the order passed by National Green Tribunal. What are the penal provisions? If the order of the National Green Tribunal are not complied with, it can impose punishment as well as fine. Punishment is how much? 3 years, and penalty is up to 10 crores in case of individual, and for firms it is up to 25 crores. Also, any director or manager of the firm can be punished or penalized if it is found by the tribunal that the offence has been committed on the orders or with the consent of such officer or firm. Yeah, so that's about it. I'm slowly going through, scroll through the entire note so that in case you want to take a screenshot, you can do that easily. Just hold on. I'll just zoom out a little bit in case someone wants to take screenshots page wise.